Hello everyone, welcome back to my channel. Today we are going to discuss this descriptive questions of May 22 RTP. Let's start with it. First question. Following are some of the securities issued by different companies related with each other as follows. So we have information about securities issued by different companies. Let's have a look at it. So the first company is Kleshrahit Limited. The securities issued by this company is listed non-convertible redeemable preference shares. So what are listed? Non-convertible redeemable preference shares issued on private placement basis in terms of relevant SEBI regulations. So this company, it has issued some shares. What type of shares? Non-convertible redeemable preference shares. And this company has power to appoint 2/3 of directors in Indraya Daman Limited. Let's look at the second company. The second company is Indraya Daman Limited. Securities listed non-convertible debt securities issued on private placement basis. So this company has listed debt securities and they are also non-convertible. And this company, Indraya Daman Limited, is holding 60% voting power in Sajakta Private Limited. Now let's talk of Sajakta Private Limited. Listed non-convertible debt securities issued on private placement basis. So this company also has listed debt securities on private placement basis, and this company Sajakta Limited holds 52% equity shares in Pratibodh Limited as an investment on behalf of another company in capacity of a trustee. So we have three companies here and we have the information of securities of these three companies which are listed and also their holding in another company. Let's have a look at what the question asks. Equity shares issued by Kleshrahit Limited and Indraya Daman Limited are not listed in any of the recognized stock exchange. So these first two are public companies and these companies, they've not listed their equity shares. No equity shares of both the companies are listed on a recognized stock exchange. In the context of aforesaid facts, answer the following questions. The first part asks us whether the aforesaid company can be considered as listed company. Let's now understand whether any of these companies can be classified as a listed company or not. What is a listed company? A company whose securities are listed on any recognized stock exchange, right? Whose securities are listed. Now securities include both shares as well as debentures, right? So a listed company is a company whose securities are listed on a recognized stock exchange. But there was a recent amendment in the definition of listed company and certain classes of companies are not considered as listed companies. Now what are those companies? Those companies are, the prescribed companies are: one, a public company whose preference shares or debentures are listed on a recognized stock exchange and they are non-convertible, then such a company will not be considered as a listed company. And also a private company. Now understand that a private company cannot list its equity shares, but yes, it does have a right to list its debentures on a stock exchange. So previously what happened was, when there was no amendment in the definition of listed company, even a private company whose debentures are listed on a recognized stock exchange was considered as a listed company. But now with the amendment in the definition, all the private companies who have their non-convertible debentures listed on a recognized stock exchange have also been moved out of the purview of listed companies. So do you think any of these companies can be considered as a listed company? No. Why? Let's have a look at the question once again and analyze. Because Kleshrahit Limited has its non-convertible preference shares listed and they are also listed, issued on a private placement basis. Indira Daman Limited also has non-convertible debt securities listed, and Sagjata Private Limited, it also has its non-convertible debt securities listed, and all these companies fall under the prescribed class of companies. And since they fall under the prescribed class of companies, none of the companies can be considered as a listed company. So this becomes the answer to the first question. Let's look at the second one. The second part of the question asks us, explain the relationship between the aforesaid companies. So here there are 4 companies in picture. You would say, no ma'am, there are only 3. No, there are 4 companies. One is Klesh Rahit and Indira Daman Limited, Sagjata Private Limited, and there's one more, and that is Pratibodh Limited. So there are 4 companies in picture, and we have to define the relationship between these companies. First, let's talk of the relationship between Klesh Rahit and Indira Daman. So let's name them K Limited and I Limited. What is the relationship between Klesh Rahit and Indira Daman? So Klesh Rahit has the power to appoint 2/3 of the directors in Indira Daman Limited. And we know if a company can control the composition of board of directors in another company, then that company becomes its holding company. Which means here K Limited is the holding company of Indira Daman Limited. Which means Indira Daman is the subsidiary of Klesh Rahit. Let's look at the relationship between Indira Daman Limited and Sagjata Private Limited. So Indira Daman Limited holds 60% voting power in Sagjata Private Limited, which means here I Limited is exercising control over more than 50% of the total voting power, which means here I Limited becomes the holding company of Sagjata Private Limited. So here we have established 2 relationships between K Limited and I Limited. There's holding subsidiary relationship, and between I Limited and S Limited there's again a holding subsidiary relationship. Now K Limited, let's look at the relationship between Klesh Rahit Limited and Sagjata Private Limited. So again we know that a subsidiary of subsidiary is also considered as a subsidiary, which means that Klesh Rahit Limited will become the ultimate holding of Sagjata Private Limited. Now let's look at the relationship between Sagjata Private Limited and Pratibodh Limited. So Sagjata Private Limited, it holds 52% equity shares in Pratibodh Limited as an investment, but it is holding these investments in the capacity as a trustee on behalf of any other company as a trustee. So a holding subsidiary relationship will not come into existence here. Why is that so? Because here Sagjata Private Limited is holding shares in Pratibodh Limited in the capacity of a trustee on behalf of another company, and this is a specific exclusion given in the definition of a subsidiary company. So very simple question, and we were also able to answer it very quickly, right? You can have a look at the suggested answer here. So if you have a look at the suggested answer, the first part asks us about listed company. So in the first part you will have to give the definition of listed company, then what are the specific exclusions from the definition of listed company, that is what are the prescribed classes of companies. And as you can see, all the 3 companies are shall not be considered as listed company because they fall under the prescribed classes of companies. Then talking of the holding subsidiary relationship, we'll first have to write the provision. So as you all know, whenever a case study based question comes, you first have to write the provision you're using to solve the answer. After the provision, analyze the case, and finally give your conclusion. So that's what has been done here. So the entire definition of holding subsidiary is mentioned, and then the relationship between different companies have been determined. So you can have a look at the answer. Let's move on to the second question. Let's look at the second question. Abhiyogik Limited, having 1,000 members, having 1000 members with paid up capital of 1 crore decided to hold its AGM on 21st August 2022, and it received a notice on 2nd July 2022 from its 60 member holding paid up capital of 7 lakhs in aggregate for a resolution to be passed at the AGM for appointing Vidya and Company as its auditor from FY 22-23 onwards, instead of existing auditor Chepal and Company, which was originally appointed for 5-year term and had completed its 4-year term. So what has happened here? So there's AGM of company on 22nd of August 2022, and a few members of the company, they want to remove the existing auditor and appoint a new auditor in place of the existing auditor. So section 140 subsection 4 says that in order to appoint a new person in place of the existing auditor, a special notice under section 115 is required. So these shareholders, they'll have to give a special notice if they want to appoint someone else in place of the already existing auditor. And special notice under which section? Under section 115 has to be given. Now section 115 has its own provisions. We'll look at them in some time. Let's first understand the question. Now what does the second part say? Such a notice of resolution was forthwith sent by the company to Chepal and Company. So a company received this notice from 60 members, and this notice was sent to the existing auditor Chepal and Company, which gave its representation in writing to the company along with a request for its notification to the members of the company, but it was received too late. So company sent the notice to the existing auditor, and in response to the notice, the existing auditor also sent a reply to the company, but his reply was received by the company very late, that is only 3 days before the meeting. Look at what happened ahead. In the context of aforesaid facts, please answer the following questions. Let's look at the questions. The first part asks us whether the said notice was given by adequate number of members within the prescribed time limit to Abhiyogik Limited. So let's answer this first part. So how many members gave the notice? 60 members. And what was the aggregate holding of these 60 members? It was 7 lakh rupees. Now section 115 says that a special notice has to be sent to the company by members not holding less than 1% of the total voting power or not less than 5 lakh of paid up share capital in aggregate. So here 7 lakhs is greater than 5 lakhs, which means the second limit has been complied with, which means the notice has been sent to the company by adequate number of members. But was the notice sent within the adequate time? So the notice has to be sent not earlier than 3 months, but at least 14 days before the meeting. Now the meeting is on 22nd of August and the notice was sent on 2nd of July. Now this date falls within this time limit. It is not earlier than 3 months, and it is also at least 14 days prior to the meeting, which means the notice which was sent by the member, it was sent by adequate number of members and also within the prescribed time. So this becomes the answer to our first question. Now how are you going to write the answer? First write the provision, section 140 subsection 4, then section 115, and then comes our analysis wherein we say that the notice has been sent by adequate number of members since their holding is more than 5 lakhs, and it is also been sent within the prescribed time limit, that is not earlier than 3 months and at least 14 days before the meeting. Let's look at the second part of the question. The second part asks us whether the company was bound to send to its members such representation made by Chepal and Company, and if it could not have been sent, then in such a case what was the responsibility of the company? So we have understood in the question that the existing auditor did send the representation, but they sent it very late, that was only 3 days before the meeting. Now in this situation, this representation could not be sent to the members of the company. Now Jaypal and company may request the company to read out the representation during the AGM, and that's what the company can do. Otherwise, the company is not bound to send the notice to its members because it has received the representation from the existing auditor, that is Jaypal and company, very late. Again, a very simple question, right? See, why are we able to answer the question properly? Because we understood the question. Now, just like in my previous video, I told you first read the requirement of the question. In this question also, if we would have previously read what the question asked, at the time of reading the question itself, the answer would come to us. अभी यहाँ पे हमने क्या किया था, हमने पहले क्वेश्चन पूरा पढ़ा, उसके बाद में रिक्वायरमेंट पढ़ा. So what happened? We first analyzed the questions and then again did an analysis to answer the question. But if we would have read the requirement part earlier, then at the time of reading the question itself, we would have our answer in our hand. So this is one thing which you can do in your exam to reach to an answer quickly. And also not wasting a lot of time reading the same question again and again. Reading the requirements before reading the case study will definitely help you. Now you can have a look at the answer as given in your revision test paper here. So as we discussed, section 140 subsection 4, a special notice is required to pass such resolution as per section 115. Section 115 says that the notice shall be given by members holding not less than 1% of the total voting power or holding shares on which aggregate sum, not this is less than, the provision is changed, it should not be exceeding, it should be less than 5 lakh rupees as may be prescribed has been paid up, and also 3 months and 14 days limit. So as we discussed, here comes the analysis. So this was the provision, this is the analysis, and then the final conclusion. Now to answer part B, again give the prescribed rule, prescribed section, prescribed provision, and then finally give your answer. So apart from giving right to be heard orally to Jaypal and company, shall also make representation read out at the AGM, and if so required, they shall also file representation with the registrar respectively. So these are the rights which the existing auditor has. Let's move on to the third one. Vrinda Limited is a company manufacturing orange and strawberry candies for kids. Now the company wants to expand its business and start the manufacturing of 10 more types of candies. So it is initially in manufacturing of orange and strawberry candies, but now it wants to expand its business and add 10 more varieties. The company has raised 1 crore through the issue of non-convertible debentures, not constituting a charge on the assets of the company and listed on a recognized stock exchange as per the applicable regulations made by SEBI. So what has happened? This company, it has raised how much amount? 1 crore. By what? By issue of NCDs, that is non-convertible debenture, and they do not constitute a charge on the assets of the company. That is, no charge has been created on the assets of the company, and it is listed on a recognized stock exchange as per the applicable SEBI regulations. Now if you remember rule 21C of company acceptance of deposit rules, it says that a company which has raised money, which has received any amount by issue of non-convertible debentures without creation of any charge on the assets of the company and listed on a recognized stock exchange, such an amount will not be considered as deposit. So here the amount which is received by Vrinda Limited is not a deposit. Very simple. Yes, it is. So you can have a look at the answer here. So as per subclause 9A of Rule 21C of Company Acceptance of Deposit Rules, any amount raised by issue of non-convertible debentures not constituting a charge on the assets of the company and listed on a recognized stock exchange as per the applicable regulations of SEBI are not considered as deposit. So this amount which is raised by Vrinda Limited is not a deposit. Moving on to the next question. So question number 4. The Board of Directors of Plum Limited proposes to issue a prospectus inviting offers from the public for subscribing to the equity shares of the company. State the reports which shall be included in the prospectus for the purpose of providing financial information under the provisions of the Companies Act 2013. So again, this is a direct question. This is not a case study based question. It's just that a company wants to issue a prospectus in order to invite subscription from public, and it is asking you what are the reports which shall be included in the prospectus for the purpose of providing the financial information. So the matters to be stated in prospectus are given by section 26 of the Companies Act, and it gives us a lot of details. Let's have a look at the section. And as per section 26, every prospectus issued by on behalf of public company, either with reference to its formation or subsequently, it shall be dated and signed and shall contain such information as set out by SEBI, as is specified by SEBI in consultation with the central government. Provided that until SEBI specifies the information and reports on financial information, the regulations made by Securities Exchange Board under Securities Exchange Board Act in respect of such financial information shall apply. According to clause C, the prospectus shall make a declaration about the compliance of provisions of Companies Act and a statement to the effect that nothing in prospectus is contrary to the provisions of this act. This act means the Companies Act, the Securities Contract Regulation Act and the SEBI Act, and also the rules and regulations which are made thereunder. And accordingly, Board of Plum Limited, which wants to issue prospectus, shall give reports which are specified by the Securities and Exchange Board in consultation with the central government, and shall comply with the provisions of Companies Act, the Securities Contract Regulation Act and the SEBI Act. The fifth question. One of the matters contained in the articles of Theman Foundation, incorporated as a limited company under Section 8, so this is a Section 8 company, was altered by passing a special resolution in its general meeting, and thereafter intimation for the same was given to the Registrar of Companies. However, such alteration in the articles was opposed by Dwaj & Company, a partnership firm which is its member, and that such alteration was not valid. Advice as per the provisions of Companies Act whether the contention of Dwaj & Company was valid and whether it can be a member in such a company. So this is a Section 8 company. Theman Foundation is a Section 8 company. So what did this company do? This company altered one of its articles, one of the matters which is contained in the articles, by passing a special resolution in a general meeting, and after that they sent the intimation about the change to the Registrar of Company. Now a Section 8 company cannot simply alter its articles by passing a special resolution. They first require permission from the central government, which is represented by the Registrar of Company. So permission of Registrar is essential before altering any of the articles. But here the company did not seek any permission. What did they do? They simply altered the article and then intimated the ROC. So here the contention which is made by its member Dwaj & Co is valid. Why? Because the company did not take permission from the registrar. Now the second part of the question asks us, can Dwaj & Co become a member in a company? Now why is this question being asked? Because Dwaj & Co is a partnership firm. A partnership firm can become a member in a Section 8 company. Therefore yes, Dwaj & Co is also eligible to become a member in Theman Foundation. Let's have a look at the answer. According to Section 8, a company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of central government, where the power has been given to the ROC. And yes, a firm may become a member in a company registered under Section 8. And here one of the articles was altered by passing a special resolution, and then the intimation was given to the registrar, which means previous approval was not taken, and it is necessary to take previous approval of registrar, which was not done by the company. Therefore the contention of Dwaj & Co is valid. And yes, Section 8 allows a firm to become a member, hence Dwaj & Co can become a member of Theman Foundation. Let's move on to the next question. Question number 6. Mr. Abhi is a chartered accountant and MBA by profession. So who is Mr. Abhi? Mr. Abhi is a CA and MBA. He has been appointed as an executive director on the board of XYZ Limited. So Mr. Abhi has been appointed as an executive director of XYZ Limited. His job profile includes advising the board of directors of the company on various compliance matters, strategies, business plans, and risk matters relating to the company. Keeping in view the above position, whether Mr. Abhi can be classified as a promoter of XYZ Limited, please examine the same under the provisions of Companies Act 2013. So we have to analyze whether Mr. Abhi can be classified as a promoter or not. So who is a promoter? 2 clause 69 of the Companies Act 2013 defines a promoter. It says a person who is named as a promoter in the prospectus of the company, a person according to whose instructions or directions the board of directors of the company are accustomed to act, or a person who directly or indirectly takes part in the decision making process of the company. But yes, this definition specifically excludes a person who acts in a professional capacity. If a person is taking decisions in his professional capacity or giving directions to the directors in his professional capacity, then in that situation he will not be termed as a promoter, though according to his directions the board of directors are working. So here in this situation, Mr. Abhi, who is a chartered accountant and an MBA, he will not be considered as a promoter just because he is advising the board of directors on different parameters. So as per section 2 clause 69, Abhi cannot be classified as a promoter of the company. Let's have a look at the answer to question number 6. 2 clause 69, a promoter means a person who has been named as such in the prospectus, has control over the affairs of the company directly or indirectly, in accordance with whose advice, directions, instructions the board of directors of the company are accustomed to act, provided that nothing in subclause C, that is nothing in this clause, that is if someone is giving instructions or directions to the board, they shall not apply to a person who is acting merely in a professional capacity. As the job profile of Mr. Abhi is only limited to advise the board of directors on various compliance matters, strategies, business plans and risk matters relating to the business of the company, and that too only in professional capacity, he will not be classified as a promoter of XYZ Limited. So that's what we discussed. Mr. Abhi cannot be considered as a promoter or cannot be classified as a promoter since he is acting in a professional capacity.